Really quick, I'll go to 4076, and it talks about, this kind of goes to the fact that the whole unauthorized employment misrep extension of status out reference, that's going to be something people are going to get hit because they may, on the I-539 extension of status, there's going to be mistakes that people happen and they're going to cause them to look like misrep on that form. Okay, so here are the problems they've had. Risks with the F1 classification. This is why they're doing this. Since 2008, multiple school owners and others have been criminally prosecuted for pay-to-stay fraud in which school officials, in return for cash payments, falsely report that F1 students who do not attend school are maintaining their student status. How was this extension of status requirement that they're putting going to solve this issue? They also go into next page 470. These are things you complain about. It's like, how exactly does what your system you're doing that's hundreds of $1,000,000 going to solve this issue? Here on page 4078, it talks about this too. Example, students claiming to maintain status when they're not, just failing to attend class or working without appropriate authorization, or school owners not requiring enrolled students to attend class or creating fraudulent documents. That's bad, but how is creating a 4-year period for it's going to solve that situation? That part I didn't understand. I might be dense, I might not be able to understand it, but how does filing I-539 solve that other than creating a way to just cut people off on I-94 and get a 3 or 10-year bar on them if they're overstay? That's the golden goose, because the last time they tried to do this, last administration or lawsuit had to stop it. So I think they have to tag on these kind of explanations to come up with something to make it palatable for future lawsuits. But I think you clearly see over this one. Now, one educational part is they're going to have a situation where people are going to travel when they have their extension of status pending. And typically in immigration law, if you have an I-539 extension of status pending, if you travel, it doesn't automatically abandon the application. It's a very interesting thing. If you're doing change of status, it will. The first change of status, just one change of status, but extension of status, and you travel and your visa is still valid, that doesn't happen. This usually comes about because automatic revalidation, potentially if you're traveling, like Canada or Mexico. But the last action rule comes into place. They bring it here. It doesn't come into place here. So they say, for example, if you leave and have an I-20 and you come back in, CBP issues a new I-94, and that might give you more time based on a new I-20 you got. So then that way you don't need to do I-539. And so if you have an I-539 pending and you leave and you come back and CBP issues a new one, USCIS will consider the EOS abandoned and you have the I-94 on the other one. Now, typically, if they don't abandon it, if they don't realize that, which they're not going to for sure, they're going to approve a new one, and that's going to be a last actual situation where the second one applies, or potentially they consider that one abandoned or they deny it for some reason. Then you're stuck getting that the previous I-94 you had denied potentially or misread like that. So it creates a lot of confusion in the system. And the last action rule used to be like whatever last application is approved, you have to go by that. So you have to like affirmatively try to withdraw the potentially I-539 so it doesn't get caught in this loop of this black hole of a mess of stuff happening. And that last action rule is a complete mess of a rule to understand. And automatic validation from Canada and stuff, that's going to be a problem. And speaking of automatic validation, they're updating the language of it. And you see this on page 83 on section B, that they're going to change it. DHS proposes to change the admission language in the provision related to extension of the visa validity in limited situations from shall to may to clarify that CBP always maintains discretion to determine whether an alien is admissible in the appropriate period of admission. I probably should this before, but look at the statute, wherever that power comes from, to see what they say over there, if this matches what the statute is. But these are the kind of changes they're making there. Here it talks as last action stuff. While USCIS generally does not consider an application for extension of status abandoned when the non-immigrant leaves the United States, so that's good to have there, just understanding for those who are unfamiliar with the extension of status. Comes up a lot of times when you have an L1 or like an H1B extension pending, they travel, they can still come back in. They can still keep that extension going. It happens like when you have an L, that's not going to expire for 5 or 6 months. And while you're still in L1 status and you have an extension pending, you travel and come back, that doesn't necessarily cause that extension be withdrawn. So don't tell your clients to stay here. Now with Trump, who knows, stay here, be safe, but don't stop you from traveling per se, because the law doesn't say that. It says DHS recognizes the potential for a conflict if a non-immigrant receives authorization from both CBP and USCIS for what amounts to the same request. So they recognize this kind of issue that pops. So the last action will come up there. And then it goes into a lot of details about how it's going to work with this whole situation, every case pending or not, different factual scenarios, and the fact that with OPT, you're going to have to submit an extension of status in these cases. We're moving to page 84. Here it says, should an U.S. application be deemed abandoned, USCIS would continue processing any application for employment authorization. So if you have this scenario where you return and you got the I-94 anyway from CBP, so the I-539 you had pending is abandoned, your work authorization would continue. Now they say that, but we all know how this bureaucracy works. So that creates another issue that's going to happen. They mistakenly deny the EAD because the I-539 was abandoned or denied, or it just becomes a mess. That's going to happen. That's something it's going to create a lot of immigration legal work to try to fix this up. And students are at this point, a lot of times most of the times they don't hire lawyers, but at this point they'll be wise to do that for those who do end up coming to the United States. There's one factual thing this morning I read, or yesterday morning I read, LA Times, it was this morning, that said that because of the financial difficulties schools are experiencing with lower admission and the costs going and everything like that, for a four-year undergraduates, there's less and less of those, I mean, to college, I forget what they call it, the basic courses you got to take to complete your credits. They don't have enough of those. So sometimes students will come and they won't get those basic classes they need, like Biology 101, until their sophomore, junior year. And so that automatically forces them to get more and more a rising amount of people who are not able to finish an undergraduate degree in 4 years. It's going to be 5 or 6 years. So you see, and then the government might claim, oh, you're not taking care of your classes. You're taking too long to take those basic classes. You're forcing. So it creates a lot of havoc with what they're doing, essentially destroying higher education in the United States. It's literally not just this, but the F1 stuff they're doing it's crazy. They're going to destroy this like cash cow that's exists in the United States. I'm not the biggest pro higher education fan. I've had higher education. It has a lot of problems, the system we have. So some of it is probably good to fix it, but the way they're fixing it is not the way to go. But I'm preaching to a choir probably for people listening to this. F and J, this goes back into if you're admitted to DS or in the U.S. Without filing U.S. requests at the program end date, blah. I don't want to go too much into the details. There's a lot of nuanced stuff, and also people already on DS might not be affected by this. And then it goes into departs. A lot of it is repeat. Yes, it's just repeat of these facts about period of authorized stay.